We've launched a series of guides on our website on COVID-related topics. These videos are designed to support these guides, giving you options on how you digest the information. Supporting our clients through COVID is our priority, and if there is anything you do not understand, then do not hesitate to get in touch with the team. This video relates to the Coronavirus Job Retention Scheme. On the 20th of March 2020, the government announced measures to protect employers and employees under the Coronavirus Job Retention Scheme. Under this scheme, all UK employers will be able to access support from the government to continue paying part of their employees' salaries for those who would have been otherwise been laid off during the coronavirus outbreak. Employers will be able to obtain a grant from the government to cover 80% of the furloughed employees' wages, to a maximum of £2,500 per employee per month, plus the associated employers' NI and the minimum automatic enrolment employer pension contributions on that wage. The Coronavirus Job Retention Scheme has been given formal legal effect on the 15th of April 2020, and HMRC has published also on the 15th of April 2020 a further update to its guidance notes. As per the update guidance on the 15th of April 2020, the cut-off eligibility date for the scheme has been changed from the 28th of February to the 19th of March, widening its coverage. Employers who have furloughed staff who intend to do so should review scheme updates and adjust their arrangements to ensure they meet the current claim criteria. Eligible businesses are any entity with a UK payroll, including businesses, charities, recruitment agencies, and public authorities. Employers must have created and started a pay-as-you-earn scheme on or before the 19th of March, enrolled for a pay-as-you-earn online account, and have a UK bank account. Employers who are individuals can furlough employees, provided the employer pays them through pay-as-you-earn, and that they have sent a HMRC RTI submission notifying a payment in respect of the employee on or before the 19th of March. The 15th of April update of the guidance clarified that eligible employees for whom claims can be made will be identified by reference to the RTI submissions made for payments to employees on or before the 19th of March 2020. Employees can be any type of contract, including zero-hour contract or a temporary contract. The guidance expressly states that foreign nationals are eligible to be furloughed. Grants under the scheme are not counted as access to public funds, and employers can furlough employees on all categories of visa. Furloughed employees must not work for the employer during the period of furlough. Therefore, if any elements of the employment duties are being performed, the employee will not qualify for the scheme. The latest guidance provides that when an employee is on furlough, the employer cannot ask the employee to do any work that makes money for the employer's organisation or a linked organisation, provides services for the employer's organisation or any linked organisation. There is a very limited exception for directors who can carry out particular duties to fulfil the statutory obligations they owe to their company, to the extent where necessary. The guidance states that if an employee is working but on reduced hours or reduced pay, they will not be eligible for the Coronavirus Job Retention Scheme. If the employee is put on furlough by more than one employer, they will receive separate payments from each employer. The 80% of their normal wage up to £2,500 monthly cap applies to each job. As per HMRC's updated guidance on 15th of April, Employees that were employed as of the 28th of February and on payroll and were made redundant or stopped working for the employer after that and prior to the 19th of March can also qualify for the scheme if the employer re-employs them and puts them on furlough. This applies to employees that were made redundant or stopped working for their employer after the 28th of February, even if the employer does not re-employ them until after the 19th of March. The 9th of April version of the guidance clarified that the Coronavirus Job Retention Scheme is not intended for short-term absences from work due to sickness, and there is a 3-week minimum furlough period. Short-term illness or self-isolation should not be a consideration in deciding whether to furlough an employee. If, however, employers want to furlough employees for business reasons and they are currently off sick, employers are eligible to do so, as they are with other employees in these cases. The employee should no longer receive sick pay, would be classified as a furlough employee, and the employers are also entitled to furlough employees who are being shielded or off on long-term sick leave. It is up to the employers to decide whether to furlough these employees. Employers can claim back from both the Coronavirus Job Retention Scheme and the SSP rebate scheme for the same employee, but not for the same period of time. When an employee is on furlough, an employer can only reclaim expenditure through the Job Retention Scheme and not the SSP rebate scheme. The guidance also clarifies that individuals with coronavirus-related caring responsibilities may also be furloughed. This is an important extension to the scheme aimed at some of the practical difficulties many are facing. Apprentices may be furloughed in the same way as other employees, and they can continue to train while furloughed. However, an employer must pay the apprentices at least the apprenticeship minimum wage, national living wage, or national minimum wage as appropriate for all the time they spend training. The guidance confirms that salaried directors are eligible for furlough, but makes it clear that directors owe statutory duties to their company. It would be for the company's board to make a decision on whether a particular director can be furloughed. Furloughed directors can still fulfil their statutory obligations as long as they do no more than is reasonably judged to be necessary. However, they must not do work of any kind that they would carry out in normal circumstances to generate commercial revenue or provide services to or on behalf of the company. When employees return to work, they must be taken off furlough. They can be furloughed multiple times, but each separate incident must be for a minimum of 3 consecutive weeks. It is vitally important to appreciate that the employer cannot unilaterally place an employee on furlough unless that is permitted under the employment contract. Neither can the employer unilaterally reduce a person's salary. Normal employment law considerations still apply, and employees will need to consent to being put on furlough. It is crucial that employment law advice is obtained when considering implementing a furlough scheme. The scheme pays a grant to the employer. The grant is a reimbursement to the employer. Therefore, the employer will make the wage or salary payment to the furloughed worker and then be reimbursed by HMRC. Employers will need to designate affected employees as furloughed workers, notify these employees. The updated guidance makes it clear that there must be written record of agreement which must be retained for 5 years. This may be in email form. They must submit information to HMRC about the employees that have been furloughed and their earnings through a new online portal. For directors, the decision to furlough should be formally adopted as a decision of the company and noted in the company's records, as well as being communicated in writing to the director. Initially, the government intended for the Coronavirus Job Retention Scheme to run at least 3 months from the 1st of March to the end of May, but it was announced on the 17th of April that it would be extended for 1 more month to the end of June. The government funding available under this scheme overall is unlimited. This is a very complex topic, and this video should be watched only as a summary, and please refer to our guide for extended details. Included in the guide are examples of calculations as well. If you have any questions on this area, please get in touch with our expert team. Thank you.